Indian Contract Act 1872. We are going to discuss about the essential elements of a contract, offer, and acceptance. This is my personal notes. And let's see, the law relating to contracts in India is contained in Indian Contract Act 1872. The act was passed by British India and is based on the principles of English common law. It extends to the whole of the idea. It determines the circumstances and which promises made by the parties to a contract shall be legally binding on them. All of us enter into a number of contracts every day, knowingly or unknowingly. Each contract creates some rights and duties on the contracting parties. Hence, this legislation, Indian Contract Act of 1872, being of a skeleton nature, deals with the enforcement these rights and duties the parties in India. Commencement Act, the act come into effect from September 1st, 1872 and applies to all contracts in India. If you see proposal, if according to section 2A of Act, when one person signifies to another his willings to do or to abstain from doing anything with a view to abstaining the assent of that other to such act or abstentions, he is set to make a proposal. Okay. According to Section 2A of Act, when one person signifies to another his willings to do or to abstain um, from doing anything with a view to obtain the assent of that other to such act to abstentions, he is said to make a proposal. Acceptance, if I see, as per section 2b, when the person to whom the proposal is made signifies his assent thereto, the proposal said to be accepted. A proposal, when accepted, becomes a promise. As per section 2b, when the person to whom the proposal is made significance is assent thereto, the proposal said to be accepted. A proposal when accepted become a promise. Section 2c defines the person making the proposal is called promiser. Promiser. The person is called, second section, repeat, sorry. Section 2c defines that the person making the proposal is called the promiser and the person accepting the proposal is called the promisee. Agreement. See, section 2e. Every promise and every set of promises. Every promise and every set of promises forming the consideration for each other is an agreement. Repeating, according to the section 2e, every promise and every set of promises forming the consideration for each other is an agreement. As per section 2f, promises which from the consideration are part of the consideration for each other called reciprocal promises. Repeating, as per the section 2f, promises which form the consideration are part of the consideration for each other called reciprocal promises. Coming to next one, void agreement. According to Section 2G, void agreement, an agreement not enforceable by law is said to be void. Repeating, what is void agreement? According to Section 2G, an agreement not enforceable by law is said to be void. Next one, contract. Section 2H defines the term contract as an agreement enforced by law. As for Section 2J, 2I, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. Next one, voidable contract. Now, Section 2I defines a voidable contract as an agreement which is enforceable by law. The option of one or more of the parties thereto, but not at the option of other or others. Repeating, voidable contract. Section 2I defines uh, a voidable contract as an agreement which is enforceable by law and the option of the one of the more of the parties thereto, but not at the option of the other or others. Coming to essential of a valid contract. Section 10 provides here. Section 10 provides that all agreements or contracts, if they are made by the free consent of parties competent to contract for a full lawful consideration and with a lawful object and are not otherwise expressively clear to be void. Coming to few following are requirements to for a valid contract. See what are those. Uh, the first one, there shall be an offer or proposal by one party and acceptance of the proposal by the other party, which results is an agreement. The shall second one, there shall be an intention to create legal relations or an intent to legal consequences. The agreement shall be supported by a lawful consideration. Fourth one, the parties to the contract shall be competent to contract. There shall be free consent between the parties to the contract. The object and consideration of the contract shall be legal and the same shall not be opposite to public policy. The terms of the contract shall be certain. The agreement is capable of being formed, i.e., it is not impossible of being performed. Okay, this is and now last one, offer and acceptance. The term proposal is otherwise called as an offer. An offer is a proposal by one person whereby the expresses his willingness to enter into a contractful obligation in return for promise, act, or forbearance. Section 2A of the Act defines a proposal or offer as when one person signifies to another his willingness to do or abstain from doing anything with a view of obtaining the assent of that other to such act or abstinences. The person making the proposal called as offerer or proposer, and the person proposal is made called as offeree. Offeree. The offer must be a valid one. The following some few points are be taken in account for the valid offer. The offer must be is in clear, definite, complete, and final in terms. It should not be It should not be vague in terms. The offer must be communicated to the offeree. The offer becomes effective only when it has been communicated in the offeree so as it give to him an opportunity to accept or reject the offer. Third one, the communication may be in writing or oral. The communication may be in expression terms or implied terms. The offer may be a general or specific. If an offer is made to a specific person, it is called such specific offer. Such offer can be accepted by such specific person. If an offer is made to the world at large, it is a general offer. It can be accepted by any member of general public by fulfilling the condition laid down in the offer. Communication of offer is a complete when it comes to the knowledge of the person to whom it is made. Section 4. An offer which has been communicated properly continues as such until its lapses are revoked by the offerer or rejected or accepted by the offeree. An ideal offer should have all the essential of a valid contract as once it is accepted by the offeree. It becomes a contract. Revocation of offer. Section 5 provides that a proposal may be revoked at any time before the communication of acceptance. Acceptance is complete as against the proposer but not afterwards. Example, a proposes by a letter sent by the post to sell his house to B. A sent a letter. It's a proposal sent to B to sell his house. B. B accepts the proposal by a letter sent by the post. A may revoke his proposal at any time before or at the moment when B posts his letter of acceptance, but not afterwards. Section 4 provides that the communication of revocation is complete and as against the person who makes it when it put into a course of transmission to the person to whom it is made, so as to be out of the power of the person who makes it, as against the person to whom it is made when it comes to his knowledge. Example, a revokes his proposal by telegram. The revocation is complete as against a when the telegram is dispatched. It is complete as against B when B receives it. As per section 6, a proposal is revoked by communication of notice of revocation by the proposer to the other party by the lapse of the time prescribed is such proposal for his acceptance, or if no time is so prescribed, by the lapse of reasonable time without communication of acceptance. By the failure of the acceptor to fulfill a condition precedent to acceptance, or by that death or insanity of the proposer. In the fact of this death or insanity comes to the knowledge of the acceptor before acceptance. Okay, coming to next one. A proposal also stands revoked if it is not accepted in the prescribed mode and if no mode is prescribed in some usual and reasonable manner, or the offer makes a counter offer. Acceptance that constitute a promise. The intention of the parties must be communicated. One cannot accept an offer which had not been communicated to him. In general, uncommunicated offer cannot result in a promise. The term acceptance means admitting and agreeing to something, to accede to something or to accept something. An offer to enter into legal relations upon the definite terms to create legal relations must be followed by an intention of the other offeree to accept that offer. In Tawada Perumal v. Union of India, A 1955 SC 468, the Supreme Court held that before an offer can become a binding promise and result is an agreement, it must be accepted either by the words or acts. A person cannot be bound by a one sided offer which never accepted, particularly when the parties intended that the contract should be reduced in writing. A promise cannot bind its maker unless the promise has assented to do it. Section 4 provides that communication of an acceptance is complete. Uh, if you see an against proposer when it put into a course of transmission to him as so as to be out of the power of the acceptor, as against the acceptor when it comes to the knowledge of the proposer. Example, a proposer by letter to sell house to a B at a certain price. B accepted a proposal by a letter sent by post. The communication of the acceptance is complete. As against A when the letter is posted, and as against B when the letter received by A. The following shall be taken into account in the case of acceptance. It may be expressed or implied. If a particular method of acceptance is prescribed, the offer must be accepted in a prescribed manner. It must be unqualified and absolute and must correspond with all terms of the offer. The conditional acceptance will amount to rejection offer. A counter offer for acceptance will also amount to reject of offer. Put the counter offer may be accepted or rejected by the other party. It must be communicated to the officer since acceptance is completed the moment it is communication. Mere silence and a part of the offeree does not amount to acceptance. The acceptance should be given if there is a time limit is fixed or otherwise at a reasonable time and believe he offer lapses revoked. Okay, next revocation of acceptance. Section 5 provides that an acceptance may be revoked of any time before the communication of acceptance is a complete as against to the acceptor but not afterwards. Example, A proposes by a letter sent by the post to sell his house to B. B accepts the proposal by a letter sent by post. B may revoke his acceptance at any time before or at the moment when the letter communication is reaches A, but not afterwards. Section 4 provides that the communication of a renovation is complete as against the person who makes it. When it is put into a course of transmission to the person to whom it made, so as to be out of the power of the person who make it and as against the person to whom it made when it comes to his knowledge. Example, B revokes to his acceptance by telegram. B revocation is complete as against B when the telegram is dispatched and as against A when it reaches him. Okay, coming to next, void and voidable agreements. Void agreement, the following agreements are considered to be void. Some few. It's my lesson, so this is my notes. I'm just, maybe it's useful to you and useful to me. Just okay, we'll go. Void agreement. If consideration or objects are unlawful in part, section 24. Agreements without consideration, section 25. Agreement in restraint of marriage, section 26. Agreement is restraint of trade, section 27. Agreement in restraint of legal proceedings, section 28. Once again repeating. Few agreements are considered to be void. I mean void and voidable agreements. Coming to the void agreement, few if consideration and objects are unlawful part, section 24. Agreements without consideration, section 25. Agreement in restraint of marriage, section 26. Agreements in restraint of trade, section 27. Agreement in restraint of legal proceedings, section 28. Okay, next one, agreements void for uncertainty, section 29. Repeating, agreements void for uncertainty, section 29. Agreements by way of wager, section 30. Consideration objects unlawful in part. Next one, consideration objects unlawful in part. Section 24 provides that if any part of a single consideration, one consideration for one or more objects or anyone or any part of any one of several consideration for a single object is unlawful, the agreement is void. Example, a promise is superintended and behalf of B. A legal manufacture of indigo and an illegal traffic in other articles. Example, this is repeating, a promises to superintend on behalf of B a legal manufacture of indigo and a illegal traffic in other articles. B promises to pay a salary 10,000 a year. The agreement is void. The object of A is promises and promise and consideration of for B promise being in a part unlawful. The section has no application to a contract which is a single contract and has no contingent part. Agreement without consideration. Section 25 provides that an agreement made without consideration is void unless it is writing and registered, it is expressed in writing and registered under the law for the time being in force for the registration of documents and is made an account of natural love and affection between the parties standing in near relation to each other unless. So next one, second one, if it is a promise to compensate for something done, it is promise to compensate wholly or in part a person who has already voluntarily done something for the promiser, something which the promiser was legally uncompellable to do, or unless. Third one, it is a promise to pay debit barred by limitation law. It is promise made in writing as signified the person to be charged herewith, or by the agent generally or specifically authorized in that behalf to pay wholly or in part a debit of which the creditor might have enforced payment but for the law for the limitation of suits in any few cases such an agreement is a contract. Okay, next one. Coming to explanation to this section provides that nothing is in this section affect the validity as between the donor and done of any gift actually made. Explanation 2 to the section provides that an agreement which the consent of the promiser is freely given is not void merely because the consideration in inadequate, but the in advocacy in advocacy of the consideration may be taken into account by the court is determined in the question whether the consent of the promiser was freely given. Examples, if you are going to see a promises for not consider so no consideration. Example, this is example. A promises for no consideration to give 1,000 rupees. This is a void agreement. A for the natural love and affection promises to give his son B 10 sorry 1,000. A put his promise to B into writing and registers. This is a contract. Third one. A finds B purse and gives it to him. B promises give A 50 rupees. This is a contract. Fourth one. A supports B's infant son. B promises to pay A's expenses in so doing. This is a contract. A owes B 1,000 rupees, but the debit is barred by the Limitation Act. A signs written promises to pay B 500 an account for the debit. This is a contract. A agrees to sell a horse of 1,000 for 10 rupees. A's consent to the agreement was freely given. The agreement is a contract notwithstanding in advocacy for the consideration. A agrees to sell a horse of 1,000 for 10 rupees. A denies this is a concept to agreement was freely given. The advocacy for consideration is a fact which court should take into account in consideration whether or not a consent was freely given. Coming to next one. Agreement in a restraint of marriage. Minor is what? Minor is what? Agreement is restraint of trade. Section 27 provides that every agreement by which one is restrained for exercising a lawful possession, trade or business of any kind is to that extent void. For exception is to this section is saving for agreement not to carry on business of which goodwill is sold. One who sells the goodwill for sells the goodwill for a business may agree with the buyer to refrain from carrying on the similar business within specified local limits so long as the buyer or any person deriving title that to the goodwill for him carries on a like business therein, provided that such limits appear to the court reasonable, regard being had to the nature of business. Agreement is restraint of legal proceedings. Section 28 provides that every agreement by which any party thereto restricted absolutely for enforcing his rights under or in respect of any contract by using legal proceedings in the other tribunals, or which limits the time within which he may thus enforce his rights, or which extinguishes the rights of any party thereto, or dispatches any party thereto from any liability under or in respect of any contract or expiry of the specified period, so as to restricted any party from enforcing his rights is void to a that extent. Exemptions. The few are following are exceptions to this section. First one, saving of contract to refer to attribution dispute that may arise. This shall not be render illegal a contract by which two or more persons agree that one dispute which may arise between them in respect of any subject or class of subjects shall be referred to attribution, and that only the amounts awarded in such attribution shall be recoverable in respect of this dispute so referred, saving of contract to refer questions that have already arisen. Nor shall this section render illegal any contract in writing by which two or more persons agree to refer to attribution any question between them which has already arisen, or affect any provision of any law in force for the time being as the references attribution to attribution, saving of guarantee agreement of a bank, a financial institution. This section shall not render illegal a contract is writing by which any bank or financial institution stipulate a term and a guarantee of any agreement, making a provision for guarantee for a extinguishment of the rights of discharge of any party, therefore thereto from any liability under or in respect of such guarantee or agreement on the expiry of the specified period, which is not less than 1 year from the date of the occurring, or any non-occurring of a specified event for extinguishment or discharge of such party from the said liability. So this is for today. And tomorrow we are going to discuss about agreements void for uncertainty, section 29. I am going to tell you. Thank you, and I need to take some water. Uh, Bye. Good day.